Thank you for having me here to speak on one of the basic principles in law, but where an artificial person is involved. I will try my best to put across my thoughts on the same. I will deal with the topic from a more practical perspective, as has been the endeavor of PLEA in most of its lectures. For this, I start with the concept of vicarious liability and then move on to examine its application in litigation and the courts. To support this examining of the topic, I will discuss various instances with all the participants here to give this more of a classroom kind of feeling. And with this endeavor of making this session interesting, let's start with our common topic in the law books, especially torts, a well-established and well-known principle, a principle evolved from common law, a principle that finds place in the maxim, qui facit per alium, facit per se. I hope I have pronounced it right, which means he who acts through another does the act himself. A principle that also finds place in law of agency, a principle that is also described in Latin to mean respondeat superior, a principle that can be extended to a known rule, that is the master-servant rule, a principle that can be extended to be known as the master-servant rule, recognized in both common law and civil law jurisdictions. So this is the principle of vicarious liability. There are many definitions and explanations in different law books. Usually every person is liable for his actions and not liable for the actions of others. But when a person is liable for the action of the other, then it is known as vicarious liability. Such liability gives rise to relationships between persons, relationship of master and servant, or relationship of principal and agent. As I have mentioned, that usually every person is liable for his own actions and not liable for actions of the others. But when a person is liable for action of others, then he becomes vicariously liable for action of that person. What we understand from this is this particular rule or principle is an exception to general rule. And this exceptional rule is based on the maxim, which I referred earlier, qui facit per alium, facit per se. That means he who acts through another does the act himself. Most of you must be knowing all these concepts and learned them already, as they are really the basics. But why this concept came into being? Why this exception to general rule? We all know what it is, but let's understand why part of it. Now, suppose, taking an example, Mr. Dashrath Prasad Sharma owns a restaurant and also delivers food at home. Now, Mr. Ram Prasad Sharma and Lakshman Prasad Sharma works for Mr. Dashrath Prasad Sharma. Lakshman Prasad Sharma and Ram Prasad Sharma both deliver goods, that is rather food, daily to different homes. Now let's pose certain questions to ourselves and answer them. First, in this entire business, who is making profit? In entire business, if the business is of delivery of food, who is exercising control over Ram Prasad and Lakshman Prasad? It is Dashrath Prasad who is exercising the control. Further, if Lakshman Prasad, for example, has 50 residences daily where he is told to deliver food, but out of those 50, he fails to deliver the food to 10 residences. Those residences ask refund for money. Then who is in capacity to pay the refund money or the damages? Answer to all three questions is Dashrath Prasad. So if profit is going to Dashrath Prasad, if control of the business is with Dashrath Prasad, control over Lakshman and Ram. And it is Dashrath Prasad who is in capacity to pay damages. Capacity to pay damages. In such scenario, profit, control, and capacity. In such scenario, who can be in position to hold the issue liable for the issues which have cropped up? Of course, it has to be Dashrath Prasad. Therefore, the concept of vicarious liability to ensure that first, person who makes profit, second, who exercises control, and third, who has capacity to pay damages or compensation, accepts the liability. In other words, a person who qualifies these three aspects is vicariously liable. Various liability are there now. Vicarious liability is a form of a strict secondary liability that arises under common law doctrine of agency respondent superior. The responsibility of the superior. So in this case, Dashrath Prasad, over and in broad sense, for the acts of third parties, that is Ram and Lakshman, right, ability or duty to control the activities of violator. So even if Lakshman or Ram have violated by not delivering the goods, the liability will be of Dashrath. Now, is this the person always an individual? The person who has liability, vicarious liability, is he always the individual? No, he can also be an artificial person. Who is an artificial person? A person who is formed because of some statute, maybe a legal entity who is incorporated, say, under some enactment. Usually, Companies Act is one such enactment. Another question also is whether state is an artificial person. Is state an artificial person? For this, I will mention Thomas Hobbes. If anyone might have come across this name, he is a philosopher and a theorist. In his introduction to his book, in one of his books, he has referred the Commonwealth or the state as an artificial man. We will see if state as an artificial person is vicariously liable during the course of this discussion of ours. Now that we have understood what is vicarious liability and what is artificial person, let us discuss what will be the vicarious liability of artificial person. Artificial person does not possess mind of its own. Its actions are a result of the thoughts of people who have formed him. So these people form an artificial person. There are two different liabilities one should keep in mind. One, that the artificial person is held liable for the action of its employees, and another is where directors or persons in charge of the particular artificial person are responsible for actions of artificial person. So vicarious liability with respect to artificial person may run both ways. There are instances when the action of the people who work for the artificial person are regarded to be the actions ordered by the artificial person. Hence, in such cases, the artificial person is regarded as responsible. We will take up some instances now and test the principle of vicarious liability and how it is applicable to artificial person. Let's say a patient is suffering from an ailment which requires a surgery to be carried out. The diagnosis is done, and so he is admitted in a hospital. The hospital, of course, has doctors. Then one of the doctors is performing treatment on the patient. He decides to carry out the required surgery. It is discovered that when the surgery was carried out, the platelet count of the patient was low. The patient died. Now, in the circumstances, carrying out surgery was not a prudent decision. and hence it is negligent action on the part of the doctor. The question here would arise is, who is responsible? Is the hospital liable for the action of doctors or not? So in this incident, the liability of the hospital to pay to the patient is vicarious. And it was held that yes, doctor is also liable. And this particular situation arose in case, I will give you the citation, AIR 2019, Supreme Court 2385. So in this case, it was held that for actions of doctor, the hospital is vicariously liable. Let's take another situation, bank and customer. Now, husband of a customer of State Bank of India gave check to the neighbor for crediting it to the account of the customer because the neighbor was employee of the State Bank of India. Now, that employee of the bank, instead of following the directions of his neighbor customer, encashed the check and misappropriated the amount. Now, in such scenario, can you, as the customer, sue the bank? Can you hold the bank responsible for the action of the employee? Well, in this incident, the liability is not on the bank because the employee has not acted in course of his employment. Remember this, course of employment. This is very important. We go back to the reason why the concept of vicarious liability came into picture. The profit earned by the principal, control of the principal over its servant, capacity to pay damage. In the instant example of bank, because the bank is not beneficiary of the misappropriated amount, it cannot be held to be vicariously liable for the act of the employee. Apart from this, of course, as I mentioned earlier, the action of the employee were not in course of the employment. This is very important. Now, this particular principle was held in AIR 1978, Supreme Court 1263. Let's move on to next incident. If there is a court order which has stayed sale of a space owned and constructed by XYZ, which is an artificial entity. In spite of such stay, the officials working for XYZ, that is the artificial person, colluded with a construction company, PQR, and caused advertisements to be published for sale of the space on which the court already had imposed stay. The purchaser are obviously played fraud upon by offering a space to sale on which there is already stay of the court. In such case, will XYZ, that is the artificial person, liable for the collusive actions of its officials? Think this is a little tough one. Here, it is not that XYZ is not bound by the actions of its officials, but where the acts and deeds of the officials are not only beyond their own authority, understand, they are beyond their own authority. And in addition to that, they are done with mala fide intent. So because they are beyond their own authority and they have done it with a mala fide intent, it is not proper to hold XYZ liable for actions of its officials. Thus, from this incident, we learn that if the servant has acted mala fide and beyond the authority granted to him by the principal, then the principal may not be held liable, that is, may not be held vicariously liable for the actions of the servant. This was case of the Supreme Court, AIR 1996. Let's take another instance. An employer, say again XYZ, required its employees to work at night at extended hours. So these employees went for dinner and came back to work in vehicle which was owned by XYZ. While returning from the dinner, the driver of the vehicle had consumed liquor. Therefore, he requested another employee who was not a driver, but he was a clerk to drive the vehicle. The vehicle met with an accident and people died. Now, the relatives claimed compensation and damages from the employer XYZ. Now, in such a situation, can those relatives demand compensation or claim compensation and damages from the employer? Now, this is very interesting in the sense if the driver himself was not driving and he has given his authority to drive or transferred his authority to drive to a clerk, then will it be called that he has acted in course of employment or not? Now, here let's see what the Supreme Court, when this case was before the Supreme Court, what the court observed. I will read it for you. The court said, if the dispute revolves around mode or manner of execution of the authority of the master by the servant, the master cannot escape the liability so far as the third parties are concerned, on the ground that he had not actually authorized the particular manner in which the act was done. In the instant case, it has been established beyond doubt that the driver of the vehicle had been fully authorized to drive the vehicle for a purpose connected with the affairs of the state. And the dispute is only in respect of the manner and mode in which the said driver performed his duties by allowing another employee of the state government who was also going on an official duty to drive the vehicle when the accident took place. Once it is established that negligent act of the driver and respondent was in course of employment, the state shall be liable for the same and cannot escape its vicarious liability to pay compensation to the heirs of the victim. So in this case, the court held, no, you will have to pay the compensation to the legal heirs of the victim. Why? Because you cannot escape the liability just because the driver acted in a particular manner or mode. He gave his authority to someone else. Though he has given the authority to someone else, still that someone else was also driving the vehicle of the state and was going to the duty and which was in the course of employment by the state government. Let's move on to another instance. Certain goods were confiscated under Essential Commodities Act by some state authority. When the goods were returned, they were not in proper condition and they were damaged. Now, can the owner of the goods seek compensation from state? Can state claim immunity? Can it claim it as it is an act of state or a sovereign function? Confiscation is a sovereign function, so no liability is attracted. Or for that matter, many of you must have read this principle, king can do no wrong. So can the state take cover of the principle, king can do no wrong, and escape the vicarious liability? Before going into answer to this particular instance, I would like to share an instance from our ancient history of India. So there was one king, Ghiyasuddin Azam Shah. While practicing archery, his arrow missed target and pierced breast of a young man. The young man died. The young man was son of widow, helpless to whom to beg for justice, because it was the king who had shot the arrow on her son. She went to a Qazi. She complained to the Qazi about the king's action. She cried and said she wants justice against Sultan. The Qazi called the Sultan and told him that according to the law of the country, you shall be punished, but if you can please the widow by giving her compensation for the loss, you may get rid of the due punishment. The Sultan gladly paid the compensation to the widow and ensured that the widow is satisfied. The Qazi then got down from his seat and, out of respect, he showed to Sultan and bowed to him. Now, what happened further is very important. The kind Sultan drew out his sword and told Qazi, "Listen to me, Mr. Qazi. If you had failed to do justice to the widow, I would have cut your head off with this sword." The Qazi also drew his cane out and said, "If you had disobeyed my justice, Sultan, I would have beaten you with this cane." The Sultan thanked the Qazi for his brave and true judgment and embraced him. This is a kind of precedent from our very own country. Do you think from this story, we ever had this concept of sovereign immunity or the king can do no wrong? Certainly not. The concept of king can do no wrong is Western. We never had such ruling style, and we always considered state as formed by the people. This is evident from the precedent led by the kind king Sultan Ghiyasuddin Azam Shah of Bengal. In fact, even the Supreme Court, now we will come back to this instance 5. Even the Supreme Court, which was dealing with the case of damaged goods, which were confiscated by the state authority, held the concept of sovereign immunity was never known to Indian law. In this regard, I will read the portion of that judgment. The emergence of British Empire in India stands out as a unique event in the history of world. Unlike many other empires, the huge edifice of this empire was created by merely a company which was organized in England for furthering British commercial interests in overseas countries. But no less greater event was the projection of the doctrine of sovereignty and sovereign immunity for acts done by a trading company by judges presiding in higher courts. English law never succeeded in distinguishing effectively between the king's two capacities, personal and political. No such difficulty existed in our system of governance, either during British rule or thereafter. The Indian law, beginning from the Government of India Act 1858 and ending with Article 300 of the Constitution, did not acknowledge English principle of sovereign immunity. Now, I want to pose a question whether when a soldier dies in war or if there are casualties as outcome of war, can the state be held vicariously liable? Can family of soldier claim compensation and damages from the state? Well, the answer to this query is also covered by the Supreme Court in the same judgment. It says that the exercise of political power by the state or its delegate does not furnish any cause of action for filing a suit for damages or compensation against the state for negligence of its officers. Reason is simple. Suppose there is a war between two countries, or there are outbreak of hostilities between two independent states, in course of which a citizen suffers damage. He cannot sue for recovery of the loss in local courts, as the jurisdiction to entertain such suit would be barred, as the loss was caused when the state was carrying on its activities, which are politically and even jurisprudentially known as acts of state. But in respect of this particular instance of confiscation of goods, the Supreme Court has held that the defense of act of the state is not available when the state or its officers act negligently in discharge of their statutory duties. Now, in this instance, the officers who confiscated the goods and they were damaged, they were acting in capacity as officers under a statutory duty. So such activities are not acts of state, and therefore state is state was held vicariously liable. This was in AIR 1994, Supreme Court 2663. Now, what we saw till now was vicarious liability in civil cases. What about criminal cases? Considering the fact that mens rea is essential ingredient of any crime, can an artificial person be made liable? Well, it can be made vicariously liable, though the general rule in criminal law is that liability of someone cannot be bestowed upon someone else. This reflects from the general principle that a crime is composed of both actus reus and mens rea, and that a person should only be convicted if he or she is directly responsible for causing both the elements should be present. Thus, the practice of holding one person liable for actions of another is an exception and not rule in criminal laws. But an exception is carved out when there is a statutory provision only, especially when it comes to corporate crimes. Then there are statutory provisions which exist, which have vicarious liability. I had mentioned earlier that there are two different liabilities one should keep in mind. One, that the artificial person is held responsible for the actions of employees, and another is where the directors or the people in charge are responsible for the actions of the artificial person. A reflection of such liabilities will be found in many enactments which have similar provisions. One is, which you can see in front of you, 141, section 141 of Negotiable Instruments Act. It reads as, if the person committing an offense under section 138 is a company, every person who at the time the offense was committed was in charge and responsible to the company for the conduct of the business of the company, as well as the company, shall be deemed to be guilty of the offense and shall be liable to proceed against and punished accordingly, provided that nothing contained in this subsection shall render any person liable to punishment if he proves that the offense was committed without his knowledge, or that he had exercised all due diligence to prevent the commission of such offense. Notwithstanding anything contained in subsection 1, where any offender under this act has been committed by a company, where any offense under this act has been committed by a company, and it is proved that the offense has been committed with the consent or connivance of, or is attributable to, any neglect on the part of any director, manager, secretary, or other officer of the company, such director, manager, secretary, or other officer shall also be deemed to be guilty of that offense and shall be liable to be proceeded against and punished accordingly. On plain reading of the above section, the fact that the principle of vicarious liability applies to the corporation is apparent. The wrongful acts of the corporates make the directors, managers, secretary, or other officers liable and guilty. What becomes the of paramount consideration here is the role of the director or the other officers that they have played in the activities of the corporation that led to doing of a wrongful act. To understand the principle of vicarious liability as is clothed in the opposite section 141, let us take another incident. So, in this case, say Anita is an authorized signatory of ABC Limited, a company registered under the Companies Act. She issued a check in favor of which was dishonored, as a consequence of which XYZ initiated criminal action by filing complaint under the Negotiable Instruments Act. In the complaint, the company, that is ABC, of which Ms. Anita was an authorized representative, was not arrayed as an accused. So the company was not made an accused. only Anita, who is authorized signatory, was made accused. In such scenario, will the complaint against Anita be maintainable when ABC, of which she is the authorized representative, is not made an accused? Because ABC, one opinion is that ABC should have been made accused because, as per the principle of vicarious liability, for the actions of Anita, ABC also should be liable. So they, unless and until ABC is made liable, how can Anita be made liable? So this case is of importance because it settled this issue. It settled a pertinent question before the courts, that whether a director, manager, a secretary, or an officer can be accused without making the corporation for which such director, manager, or the officer is working as an accused. There was a difference of opinion between the courts in India, where one view was that corporation need not be made accused if director and other officers have been made accused. Whereas other view was that unless the corporation is made accused, how can you make the director, manager, or other officer accused? Because they have not been arraigned because of the vicarious liability principle. If the principal, that is the corporation, is not accused, then how could its agent, that is the director or other officer, be questioned for his action, which are supposedly for and on behalf of that principal? Now, the latter opinion was upheld by the Supreme Court. While deciding this issue, the Supreme Court referred to many English judgments also, and also it referred to Halsbury Law of England, where it said it has been laid down that in general a corporation is in the same position in relation to criminal liability as of a natural person, and may be convicted of common law and statutory offences, including those requiring mens rea. Further, I will like to read a portion of that judgment which will make this aspect more clear. We have referred to the aforesaid authorities to highlight the company can have criminal liability. And further, if a group of persons that guide the business of the companies have the criminal intent, that would be imputed to the body corporate. In this backdrop, Section 141 of the Act has to be understood. The said provision clearly stipulates that when a person, which is a company, commits an offense, then certain categories of person in charge as well as the company would be deemed to be liable for the offenses under Section 138. Thus, the statutory intendment is absolutely plain. So, from the provisions and the judgment, what is pertinent is that a corporation is made liable. At the same time, its directors or officers can also be made liable. But such liability can be vested upon the directors or officers only if the corporation is made accused. This is because corporation is made accused because of the principle of vicarious liability. And the directors or officers are made accused because they have role in running the corporation. And therefore, actions of corporations are deemed to be results of actions of the directors and officers. But if the corporation itself is not made an accused, then the question of making directors and officers accused cannot arise. Because then, by virtue of corporation having not made an accused, the vicarious liability as enunciated in the provisions of Section 141 will not get attracted. Like 141, this is a list of a short list. It is not exhaustive list, but similar provision are there in Drugs and Cosmetics, SEBI Act, then Environmental Protection Act, and many other, even in many labor laws. Apart from this Payment of Bonus Act, there are many other labor laws in which you will find this same provision. Okay, now we will discuss a last instance. Say there was a gang rape committed, and that particular offense was committed in the premises of XYZ company, and the offenders were employees of XYZ. Can XYZ be held liable? that is the owner of those premises, be held liable for the offense committed by the employees of XYZ. So this is also a case where the Supreme Court made certain observations. This was in fact a case where the premises belong to railways. And what Supreme Court observed, I will read. Supreme Court observed, running of railways is a commercial activity. Establishing Yatri Nivas at various railway stations to provide lodging and boarding facilities to passengers on payment of charges is a part of the commercial activity of Union of India. And this activity cannot be equated with the exercise of sovereign power. The employees of the Union of India who are deputed to run railways and to manage the establishment, including railways and Yatri Nivas, are essential components of the government machinery, which carries on the commercial activity. If any such employees commit an act of tort, the union government, of which they are the employees, can, subject to the other legal requirements being satisfied, be held vicariously liable in damages to the person wronged by those employees. Moreover, we are dealing with this case under public law domain and not in a suit instituted under private law against persons utilizing their official position. Got a room in Yatri Nivas, booked it in their own name where the act complained was committed. Thus, the state here, as an artificial person, can be made vicariously liable in certain instances of crime. So with this, I hope I have been able to throw light on how vicarious liability principle is relevant in litigation. Thank you for listening to me patiently and allowing me to put across thoughts on vicarious liability of an artificial person.